All right, everybody. It is 4:35, so we're going to get going on the presentation here. I wanted to thank everybody for joining us tonight for the Expert Forum series. Just before we begin, I do have a couple of announcements for kind of upcoming things for the Rhode Island Commercial and Appraisal Board of Realtors. I'm Christina Rouse. I'm the president of the Rhode Island Commercial Appraisal Board of Realtors. And so we've got a couple events. We've got coming up on October 19th, our highly anticipated annual Rhode Island Commercial Day is happening. That's happening over at the Crown Plaza in Warwick. It is a morning event. We have Secretary of Commerce Liz Tanner coming to be a keynote. We have a development panel. Really excited about that one. And then we do have our annual meeting coming up at the end of October, the 26th. So look for both of those in your inbox. Before we hand it over to Rick and Michael, I'll just do a quick introduction. So Rick Mandile is the owner of Sage Environmental, principal and owner. He's actually one of our sponsors as well at REALTOR, so thank you very much, Rick, for that one. He's been in the business for 33 years, and he's successfully captured and captained the largest headquartered environmental firm in Rhode Island since 1995. So congratulations for that. He's also an excellent teacher. I've attended a couple of classes that he's had over at RIAR. So really fortunate to have Rick in the game today. And then Michael Donegan oversees the firm's environmental practice over at Orson and Brusini. Mike is an experience in the area of environmental law, and he's the author and editor of the Rhode Island Environmental Law Handbook. So we're really happy to have Michael here as well with us. I do want to remind everybody to, if you can, just throw some items in the chat if you want to ask some questions, just so we don't interrupt our presentation. And we're going to flip it over to Rick to have him share his screen. So thank you for joining. Thanks, Rick.
Great. Can you see that? Christina, are you able to see?
We can see it, Rick. If you want to start the slideshow, you can do that too, so we don't get the slide.
Hold on.
We have it.
Yeah, in that top left-hand corner. Yep.
From beginning. Okay, I gotta go back here. Okay. Welcome all. Happy to be here. Mike and I did this presentation a few years back. Actually, Mike, I think it was pre-COVID, right?
Mm-hmm.
A lot has happened, both in the environmental and the real estate world since. So we've updated this presentation to reflect a number of those changes. Couple things before we start. For those of you who don't know, this presentation is being recorded, and it will be put up on the RABCOR website at some point, usually within a few days of the presentation. One of the things we've learned over the years of giving this type of a presentation, and this one in particular, is especially with the attendees here today, we've got a fantastic mix of experienced talent, ranging from both commercial and residential realtors to local lenders covering Southern New England, not just Rhode Island. We've also got folks from Rhode Island Housing signed up, which is another unique perspective. We've got a handful of lawyers as well. And so that said, a big value that we get from these presentations is the sharing of war stories. I say that somewhat tongue-in-cheek, but I would ask that you put your comments and questions in the chat room, and Mike and I will address those once we're through the presentation. Feel free to pose your questions as hypotheticals, so that we can keep the innocent, if you will. With that, this presentation by Mike and I, it's somewhat of a ping pong back and forth. We're gonna try to wrap our presentation up to leave by around 5:30 to leave about a half hour for Q&A. So with that, we're gonna jump right. All right. And whoever's laughing, please mute yourself
Or share.
or share. Uh, I'm going to hand it over to Mike, who's going to talk about who is environmentally liable and why.
All right. And so looking at the attendee list, I know many of you. So I say hello to the friends and folks I've worked with over these many years, and to those I haven't worked with yet, hope to do so soon. So when on the commercial side, when you are involved you're engaged by a client to market their property, either for sale or for lease, you represent a potential buyer. You represent a tenant that may go into a facility, right? The issue of environmental liability is one that's front and center for all sophisticated parties. And the brokers play a particular role in that, because you may or may not have knowledge, you may or may not have imputed knowledge, and you may be asked questions. Oftentimes, you're the relationship with the interested party before a contract is signed. And so you're the kind of the first touch and feel that they're going to get about environmental issues associated with this commercial property. So it's important to understand the liability schemes that may impact who has liability. So the most common one you're going to run into, right, is you have soil or groundwater contamination regulated by the Rhode Island Department of Environmental Management. So who actually has liability for that? If you have a commercial building, and let's say it's multi-tenanted, who actually has legal liability to the government? So under Rhode Island law, the responsible parties have liability to the government for remedial obligations. And responsible parties are those who cause the contamination, or what you usually see, owners and operators. So the liability is joint and several. So if you have a building owned by one company and a tenant occupying the building, or many of them, they are each 100% liable to the state government for all of the remedial obligations. That's joint and several liability. And so what ends up happening is the DEM has enforcement discretion over who they want to sue, but they're not required to exercise that in any particular way. So you may run into circumstances where it's obvious the tenant did it, but why are they going after the owner? Because they can. It's obvious that the owner did it. This predated me. Why are they going after, why are they going after me as the tenant? Because they can. So oftentimes the enforcement discretion is exercised against the deep pocket. And then what do you win if you're the tenant who has liability and to the government, and you have to remediate? You get the right to recover from the landlord or from someone else who committed the contamination. So you get the joy of spending lots of money in litigation to try and recover funds. So here's a list of who could be responsible, right? The current owner is holding the hot potato and is always liable. How about past owners? Well, that's interesting. If they didn't cause the contamination, then they are not, because they don't fall into the definition of responsible party, as they are not a current owner operator, and they didn't cause it. So if they can move the hot potato on to the next buyer, owner of the property, they've successfully moved out from under that liability. Current tenants have liability as operators. Past tenants do not, just like past owners, unless they cause the contamination. What about abutters? What if you have a groundwater plume coming from the abutting property onto your property? Yes, the DEM could go after the abutter, or they could go after you in their enforcement discretion and require you to remediate it and let you chase the abutter. We'll talk a little bit later about this, about whether you can get a down gradient receptor letter and avoid that. But how about lenders in the deals you work on? Some of you may represent private parties who do hard money or softer money lending. So what happens under Rhode Island law? Can a lender be responsible for remedial obligations? The answer is no. Under the Industrial Property Remediation and Reuse Act, which I abbreviated there, a lender is specifically protected from liability as a responsible party, even if it forecloses to protect its security interest and takes possession of the property, as long as it continues to market it for sale to recoup its losses, to recover under the note, then it is protected. If, however, they decide to hang on to it because they think it's going to increase in value, it's an investment, or if their management causes a release while in their possession, then they would have liability. One other thing you may encounter in your commercial transactions is someone might market a property that has unique characteristics. Oh, this was operated as a car dealership, and my client is a car dealer, and they want to buy this, and maybe they're going to buy the name, and maybe they're going to be in the same location and use the same signs, but it's an asset transaction. Under common law, there is the doctrine of continuing enterprise liability. So if to the rest of the world it looks like the same business is operating there, your client may inherit those liabilities. I talked about the DEM enforcement discretion. I apologize. I'm at a client's industrial facility giving this talk, and the power has just turned the lights out, I guess. So we'll keep going now. So the DEM has our enforcement discretion. They also have the ability to refer enforcement matters to the EPA if, say, our clients are large, litigious, and they don't have the resources. They can kick it up under the delegated programs to the EPA. It's rare, but it does happen. Happens far more often on air issues than it ever would on remedial issues. There's another liability scheme we haven't talked about, which is what's your liability to private parties? You buy the property, and even if you didn't contaminate it or you're a tenant there, and there's a groundwater plume leaving that property going on to an abutter's property. Under various contractual theories, under statutory law and common law, they would have claims against you. We look at specific contractual indemnities or implied obligations from contracts. If you're representing a client that thinks they're protected because they have an indemnity from the seller, or there's some implied obligation of good faith where they're giving you whatever is material, hopefully your lawyers will have drafted a very tight agreement. But there may be contractual obligations you're assuming when you buy the property or not. There are statutory causes of action under the Industrial Property Remediation and Reuse Act, the Rhode Island Clean Water Act if there's contamination, and common law claims, which to be like trespass and nuisance. So that's the liability scheme. And when you're walking into a commercial transaction, remember that tenants have equal liability under the law as owners. So if you're negotiating that deal, it's important that they have all the same protections as a buyer would have. And this is the liability scheme that if both your client and the opposing client are well represented, these are the business issues that will be negotiated that you will see.
Yep.
All right, Rick.
Okay. Write the question as a realtor. Why do I want to manage, or why do I care about environmental aid? Anything, right? Talk about duty to disclose. We understand that environmental issues can be deal killers, and you don't want to see you're an environmental consulting doing any environmental due diligence, but we all know that that's normal business practices and has been for the past 30 odd years, right? Phase ones, transaction screens. I know I'm preaching to the choir here. Most, if not all of you on this call are very familiar with the environmental due diligence process about phase ones and whatnot. We oftentimes advise sellers or their brokers to make sure that before you go to market, make sure you have your environmental house in order. Get a phase one that that doesn't have any issues on it, or if a property does have issues on it, oftentimes we will be asked to have those issues assessed and get it to the point where the remedy and the costs are known, or at least the remedy is known and approved by your regulatory agency. Speaking of, we're here in Rhode Island, that would be DEM. So oftentimes we'll go through the phase one, phase two, and remedy approval process so that that can be in hand as part of your marketing package come time of sale.
And I'll just comment that you either pay for it now, your clients do, or they pay for it in the deal. Because when they're more, it's a very imperfect market, buying and selling real estate generally. But add the vagaries of environmental liabilities to it, and no two parties are going to value that the same way. So if you represent a seller, it's recommended that they get this all in order so they're not confronted with a bigger price reduction ask due to the vagaries and uncertainties of those costs.
Right. Again, as many of you, I know many of you are familiar with the environmental due diligence process, the phase ones, phase twos, whatnot. We're going to talk more about that later on in the presentation, but there is a new or an updated phase one standard that the ASTM promulgated 2 years back. Some of that includes things like vapor intrusion. We can talk a little bit about that, as well as they've expanded their definitions of when an issue becomes an issue. And again, I'm going to talk more about that further in the presentation. And here it is. You may have heard these terms before: RECs, PECs, HRECs, CRECs, data gaps. Oh my. So I, as an environmental professional, the work that I do, the ASTM phase one criteria, it puts guardrails up on me. I have to call things as I see them. Oftentimes I'll get calls from my banker friends and lawyer friends and realtor friends saying, "Oh, Rick, every location in Rhode Island has contaminants on it. Every location's been, has been subject to some sort of filling." Yeah, I don't disagree with you, but the ASTM standard requires me as the EP, addressing that property under the phase one criteria. I have to call it as I see it. So RECs, right, they're short for recognized environmental conditions. Think of a REC as a threat of a release of oil or hazardous materials at or to a property. I may not have actual data that tells me that a property is contaminated, but I've got enough information that we've surfaced during the phase one process to say, there's likely an environmental issue here. A PEC, or a potential environmental concern, that's a term that's part of the ASTM transaction screen process. For those of you who are not familiar with the difference between a phase one environmental and a transaction screen, a transaction screen is really an abbreviated phase one, costs a little less, takes a little less time, but it is essentially the same thing, trying to identify whether or not a release of oil or hazardous materials it might be associated with a property. An HREC, a historic recognized environmental condition. That's where a site has had some type of a historic release of oil or hazardous materials, but it may not have yet been resolved by a regulatory agency. It's still sort of hanging out there. A CREC is a controlled recognized environmental condition. A CREC we would associate it with a site that may have gone through the DEM assessment and cleanup process, and that property now has been recognized by DEM to be administratively closed. It might have a letter of compliance or an interim letter of compliance or a no further action. We'll talk about those designations a little later on. The new or the most recent ASTM standard added this thing called data gaps. And one of the reasons they created this new definition of a data gap is to say, well, I'm not sure if it's a rec, I'm not sure if it's a PEC. We've surfaced a question during the phase one process that may or may not lead to a recognized environmental condition. So I, as the EP, have to call out this data gap. So for example, oh, they may have used a particular chemical on a site, but we're not sure how it was used, and we don't know whether or not it actually was released to a site. Again,
or Rick, an example is as a reference in some environmental documents and files at the DEM that reference tank closures, but there are no closure certificates.
great example. Perfect, Mike. So those are the things, right? Those are the conclusions that I, as the EP, are limited to when I do a phase one. To answer those questions following a phase one, if they do get surfaced, right? We do those with phase twos and further assessments. One of the things that Mike and I will talk a little bit more about are these things called emerging contaminants of concern. And what that means is, and we reference here PFAS and PFOA, if for those of you who may or may not have heard about these emerging contaminants of concern, these are contaminants that may not currently be regulated, but we know they're coming. And typically PFAS and PFOA are most commonly associated with fire suppressing foams. That's why I have my little fireman here blowing foam on a fire. But as it turns out, these PFAS and PFOAs, they're surfactants, they're used in just about everything. And recent studies by DEM have actually identified these contaminants literally falling from the sky. We're finding them in storm water. One of the problems with these contaminants is yeah, we've got a regulatory agency that has been charged with developing numerical standards that Mike and I have to wrestle with when it comes time to reporting on them. But these regulatory agencies don't yet have remedies developed for them. So we get caught in this sort of rock and a hard place on our phase ones or transaction screens.
Rick, I'll just say that for those of you who imagine that a consultant could invent anything is possibly going to be regulated someday, it's more specific than that. So an easy example is for PFAS and PFOA in Rhode Island. A year ago, June, the General Assembly passed a law that regulated as of July 1st, those chemicals in all public water supply systems. And I just, as an aside, I'm doing work representing URI, Warwick, Pawtucket, South Kingstown, others in dealing with their compliance with that standard as public drinking water supply systems. But it also required DEM by 12/31 of this year to promulgate regulations to address groundwater, soil, surface water, PFAS levels. So those numbers are going to be published very shortly, and there'll be a public hearing process under the Administrative Procedures Act that we all have to go through. Rick and I have some insight into that because Rick is the president of the Environmental Business Council. I'm on the board of the Society of Environmental Professionals. We all work together and stay close with DEM on those issues. But those regulations will be in place by year end. So that's an example of an emerging contaminant of concern that Rick must give an opinion on and flag when he's giving his report. We have a client collectively that said, well, it's not regulated. I don't want to do that. It's just Rick doesn't have discretion, no matter how much you lean on him, to avoid that. You know, I assume there's some super attenuated contaminant somewhere that he could say that's not really on the radar here. He could have some discretion there, but there are many of them that are so well studied, and the EPA has already issued guidance documents on them. Anything that we have to use them, whatever EPA has issued a guidance document on, is going to be a contaminant of concern, even if it's not into the law yet.
Right, right. So on this slide, for those of you who have had the pleasure of being regulated or had a client site that has been regulated under the DEM site remediation regulation process, I provide this sort of cheat sheet that we use that documents sort of start to finish how we work our way through the DEM site remediation process, from the point at which we identify a release of oil or hazardous materials using the notification. We would then generate a site investigation report, which is really a repository of a phase 1 and a phase 2 assessment, where we've tested soil and groundwater, identified that numerical release relative to DEM soil or groundwater standards or subslab soil gas standards, which DEM essentially is adopting the Massachusetts vapor intrusion guidance policy. I know I've talked with and dealt with many of you on subslab soil gas issues. Then we move down to developing the conceptual remedy to that release in the form of a remedial action work plan. We then go and execute that remedy. We document the completion of that remedy. And then at the end of the day, we hope to get from DEM either an interim letter of compliance, also known as an ILOC, or a letter of compliance, also known as an LOC. And in certain instances, DEM site remediation group can also issue what are known as no further action letters or NFAs. This regulatory process is separate and apart from DEM's underground storage tank regulations, which somewhat mirrors this process, but it's a different group that's separately managed at the department. You're on, Mike.
All right. So who has a legal reporting obligation, right, when contamination is discovered? So interestingly, you would imagine anyone who has knowledge of a release would have an obligation to report. It's just not true. The law is that responsible parties have to report. And there's an immediate reporting obligation and then a follow-up in writing. But responsible parties for our purposes and your purposes as a broker, you can think of as anybody who caused it, who's aware of it, or any owners or operators. So now we're back to fee owners and tenants. If they have knowledge of a release, doesn't mean they did it. They just have knowledge that, say, a soil standard that exceeds the residential direct exposure criteria, you're above that number, there's a reporting obligation. And Rick had mentioned tanks. Interestingly, for leaking underground storage tanks, it's any person having knowledge. So in theory, lawyers, brokers, in practice, consultants, lawyers, and brokers never make that call because you'd never work again.
Yeah.
But you know, that's in theory what that is. But a broker in this instance, a lender who comes into has this information, someone who operates public housing comes into the information. It's if you are an owner operator, by definition, you have that reporting obligation.
Right.
I will state that
I'm sorry, Mike, for those of you, right, this is specific to Rhode Island. For those of you who work in other states like Massachusetts, it's different. We're not going to go into that today, but just know that it's different.
right. And if you know, what's interesting is when I do work, say, I worked for a railroad that was divesting properties all over America, and I work for a company that develops projects throughout the country. And so they will go get batch site assessments for, 100 properties. And to address reporting obligations, you have to go and drill into each state's reporting obligation. I will kind of talk just a bit about how we manage the reporting obligation using the attorney-client privilege. So many of you on this Zoom have had this experience, right? Where your client who's going to be a tenant or a buyer wants to do a full site assessment, right? A phase 1 and a phase 2. They want to take soil groundwater samples. And the seller or the landlord are concerned, right? That you may find something that creates a remedial obligation for them, but then you'll walk away anyway. So there's often this tension about whether they'll let your client do the investigation or not. And so one of the things we can do is, instead of having the client retain, the consultant, the lawyer can retain the consultant. And as long as we use the magic language from case law, which is basically, I'm retaining Sage Environmental to assist me in rendering legal advice to my client, then we've thrown the blanket of privilege over what I learn. I have to be judicious in how I provide information to my client, but that is legal, ethical, and it's done all the time in the tax world, right? You can imagine that if one of you got audited and you're a lawyer and accountant, started going through your books and you found things, you would not be obligated to turn new information over to them. It's a similar body of case law. And so we also sign agreements that we'll talk about later, that we will commit that we will not provide the owner with any of the data. And the reason we do that is if they receive information that shows the residential direct exposure criteria have been exceeded, even on commercial property, then they have a mechanical reporting obligation. So we put it in the contract, and then often I will hire the consultants and manage that process.
Right. Mike, you want to talk a little bit about the remedial agreements?
Sure, yeah. So when you represent buyers or tenants, because we know a new buyer has 100% liability, and we also know your client who becomes a commercial tenant equally has liability. What we can do is, on the way into a transaction, either a commercial lease or a commercial purchase, we can actually apply to the Department of Environmental Management for what's, we call them, for purchases, a bona fide prospective purchaser certificate. And what that does is, it's a very, a short application, like a page, where you basically say that I've never been involved in the site, I didn't cause the contamination, I'm not an otherwise responsible party, and you sign it under, penalties of perjury, and you send it over to the DEM, and they give you a certificate. What it does is it holds your spot so that post-closing, when you take title, you are eligible for what's called a remedial agreement. A remedial agreement is often called a brownfields agreement. But what it is it's a contract with the state that says, we will go forward and investigate the property, or here's what we have, we've investigated the property, and we will bring it to closure. And the DEM agrees that if you do that, then you will have no further liability to the state. And the way that works is they give you a covenant not to sue in the contract. And they also give you something that's very helpful, which is contribution protection by statute. So no third party can sue you for that contamination. This is equally applicable if your client is going to become a commercial tenant. They should, as a matter of course, if there's any history of contamination on the site, they should get a bona fide prospective tenant certificate that holds them harmless when they become a tenant from the underlying contamination. So that is very beneficial to them and their lenders as they move forward. So that's what we call the brownfields program in Rhode Island. You, on the way in, during your due diligence phase, you would get a BFPP certificate if you're a purchaser, or a bona fide prospective tenant certificate if you're going to be a tenant. And the good part about the process is you don't need the seller or the landlord involved at all.
Right.
It's just us.
And DM moves pretty quick on those, right, Mike?
Yeah, there's no statutory or regulatory standard, so we've moved them. If you have a deal that's happening quickly, you hopefully have people who work with them, but it's a phone call and we've done them in 2 days.
Right.
Yep.
Right. Okay. Mike talked about the attorney-client privilege. For those of you, right? Can't really hear him. You all know what that was. I'm going to move on. All right. Come on. Okay. Right. Did I go too far? Nope. Okay. This one's for you, Mike.
All right. So these are the kind of deal issues you're going to encounter in your sales contracts or your lease agreements. And the reason we talk about these things that the lawyers have to handle is just so that you don't waste your time, putting a lot of energy into deals that have no chance of closing. So it's important to understand the kind of negotiations that are going to happen with the representatives of a buyer and seller team of the, in connection with a commercial lease. So the terms you're going to see in these contracts, and we'll take it from a buyer's perspective, equally applicable to a tenant's perspective. But so in the document, we would require the owner or the seller to disclose to us, will represent and warrant that there are no environmental liabilities or conditions of which they're aware. If there are any, they're set forth in a schedule so we can all discuss them. You may end up in your contract where the seller believes, or the landlord, that they are being very tricky by putting in as is, where is language. The buyer is taking subject to all faults, as is, where is. And that, by the way, has some appeal to it. You should, that makes sense. However, what does the language really mean if the seller or landlord is actually in possession of information that shows there is this contamination and there are these environmental liabilities? Whenever an owner, landlord, enters into a contract and they have information about a material fact and they don't disclose it, they open themselves up to a civil fraud claim. So it's not as if the new buyer, when they discover the massive problem, is going to stop because it said as is, where is in the agreement, nor do I think a court would. Equity would cut the other way. When we talked earlier about the seller or landlord not wanting to be stuck with a reporting obligation. So often those agreements have in them that whatever you find in due diligence, you will keep confidential. I always find those things interesting because they're heavily negotiated. And I'll talk about this in connection with the indemnity as well. We have indemnities running either way, and we have prohibitions against, the buyer or tenant providing the DEM or the public with any of this confidential information. The reason it's interesting is, though we spend a lot of lawyer time on this, if there are no consequences if we breach the agreement, you have no damages. You already have the underlying remedial obligation, so by surfacing it, it doesn't change the facts. So when I negotiate those agreements on the confidentiality provisions, I like to put in there some liquidated damages provision that if you breach this, you owe us $100,000. and something to give that's deal appropriate, that gives the buyer or the tenant some skin in the game not to breach that provision. When we look at indemnities that run both ways, I have colleagues on, participating tonight that Lauren Frisch and John Laterra-Bellino, who we worked together on a deal recently where the buyer assumed all of the liability, but often it's the seller indemnifying the buyer. Well, let's take the seller indemnifying the buyer. If it's an LLC that owns the real estate and the property is sold, right? Do I really care as the buyer? Because isn't what's really going to happen that at the closing, the money goes in, it gets distributed to the shareholders. The company that's an LLC is now assetless, had no contractual obligation to remain solvent, and will shortly cease to exist. So it's important to remember that lawyers will die on this hill that may not have the same meaning that they think.
Oftentimes, and I alluded to this earlier in the conversation, clients will say, well, can I just leave the contaminated stuff in the ground? And the answer is yes. Over the past 30 years, as our environmental regs have become more sophisticated, we've learned a lot about the actual impacts that could occur to humans or the environment. And one of the most common remedies that DEM, and I'll show you some stats in a couple of slides, is to actually leave contaminated media beneath a site. Typically, we have to leave that beneath a cap or an impermeable surface, but it is far and away one of the most used remedial strategy that is allowed by DEM, and I'll give you some numbers on that shortly. If there is contamination getting into a building, I mentioned the concept of subslab soil gas vapor intrusion, which is a very real and significant health threat that was reflected in changes to the ASTM standards a couple of years back. More often than not, in scenarios like that, we are implementing, think of a radon mitigation system in a home, essentially creating a vacuum beneath a building slab to keep those volatile vapors from getting into a building and potentially harming occupants. And then ultimately, DEM likes to tie those remedies up with the placement of what's known as an environmental land use restriction. I know many of you on this call are familiar with those terms, and particularly our lending friends on the call. They have been lending around sites that have caps and have associated ELURs now for at least 2 decades. So it's part of normal business transactions, and justifiably so. Here's some stats I got from our friends, Mike and I got from our friends over at DEM recently. So between 1990, which is when DEM's regs really were modified, till today, at present, there are almost 1,000 active sites being managed in some form of another at little DEM over here. And believe it or not, there are only 7 full-time DEM staff members who have to manage those sites along with we consultants and guys like Mike in the environmental legal community. So not a lot of staff to manage quite a number of sites here in the state. To date, there's been approximately 700 or more sites that have gone through the DEM site remediation process I showed earlier, and resulting in over 700 letters of compliance. Almost 150 sites have achieved interim letters of compliance, and ILOCs are for those sites. They call them interim because oftentimes there's a long-term monitoring effort that's required to eventually get to a letter of compliance. Usually it's groundwater monitoring or monitoring of some type of a subslab vapor capture system. I mentioned no further action decisions. Almost 400 NFAs have been issued by DM Site Remediation Group. NFAs are very specific to a smaller release on a larger property that has not, the entire property hasn't been assessed comprehensively, but the NFA is geared towards a very small singular release on a larger property. And I mentioned earlier that remedies that include capping, our friends at DM said that they believe almost 98% of the sites that they've closed to date have some form of an environmental capping requirement as part of that site closure. Moving on. Just three quick examples of sort of a capping site you see here. Capping can include pavement, a building slab, as well as landscaping areas under which we would put some type of a membrane. That's your site number here, your site number 1 here on the left. Site number 2 here is a vapor intrusion site where we needed to do some form of subslab venting to keep those vapors from entering the building. Site number 3 really is just about anything and everything you can imagine on it. Mike mentioned a site earlier. This site here is being impacted by an upgradient off-site contaminant that's entered groundwater, that's being transported off-site through our client site under his mill building and ultimately getting into a river. Our client on this one has to, as Mike had alluded to earlier, by DM, has been required to interdict the plume before that plume enters the river, leaving his site. So again, just sort of a wide variety of the stuff that we'll oftentimes need to address, sort of from the easiest to the most challenging. I'm not going to dwell too much on property condition assessments. If you think about environmental liability and due diligence, what Mike and I have been talking about so far really is geared towards ground down environmental assessment issues: soil, groundwater, subslab soil gas. Property condition assessments over the past 5, 6, 7 years is something that many of our lending clients have asked us to include as part of environmental due diligence, where we're being asked to look at ground up issues: lead, asbestos, radon, PCBs in window caulk and concrete, as well as your building systems. Again, not going to dwell on it. We're being asked to do more and more due diligence, not quite environmental, but they're being wrapped into the whole due diligence process along with your standard phase 1 or transaction screen. I'm going to skip past those.
Rick, I'll just say, when it comes to that, it's that,
Yep.
When your clients are looking to buy something and rehab it, they need to understand the hazardous building materials, because the cost to dispose of that, may not be what they think, as if it were inert and unregulated. And so that's why they want to have all of that assessed. We had a very well-known building in the downtown Providence area that had millions of dollars associated with disposal of the windows because of the PCBs in the mastic around the windows.
Right. I think our friend Mr. Sweeney may be familiar with that one. Oftentimes, Mike and I hear, people complaining about DM. Oh, their rules, their regs, staff, their everything. Trust us, we have it very good here in Rhode Island with their environmental regulatory process, and in particularly those public servants that we work with on a daily basis. Mike and I have pretty much everybody at DEM that we have to deal with on speed dial and their cell phone numbers. They are very responsive. They are overworked, underpaid, but they still, in our experience working in other states, they do a fantastic job and they are very responsive. So if and when you hear somebody bitching about DEM, stop them, please. Say, time out. Compared to what? We have it very good here in Rhode Island, and annually when DEM and the governor are up for asking for money from the governor, say yes. It's in all of our interests to make sure DEM is well funded, because ultimately that enables us to get these sites through the regulatory process faster. Let me get off my soapbox on that. Mike, you want to talk a little bit about
Yeah, so I'm going to have to
duties
speak
here?
for a lot of this because we want to give time for Q&A.
Yep.
But so what are a broker's legal duties and how do you manage your potential liability in transactions where the seller may not want to reveal much of what they know and the buyer may not discover liabilities until post-closing or after they become a tenant and then they get the big lawsuit? Like, what are you supposed to be doing as a broker? As a lender, what should you be looking at? How does this all play together? I'll just take the broker as the example. So your information falls into different categories, right? There's knowledge that you have directly, right? Your engagement with the owner of the property has given you access to information. You've talked to consultants. Maybe a deal has cratered 4 times and it did for environmental reasons, and you know some of this. Then there's a universe of things about what should you know, right? Do you have any duty of inquiry, right? Do you have title information? What's recorded there? And what is imputed to you that your information that your client possesses? So similarly, what is if the client gets sued and you knew something, but the seller makes no representations, they're going to say, I didn't know. But in the lawsuit, you'll get named and they'll say you knew. And now a jury gets to decide, is it more likely than not that the broker talked to the seller, is their own client? You don't want to be under oath ever. So we want to avoid that. I would ask yourself, the firms you all work for as brokers, what policies are in place that address what information you're requesting from your clients if they're the owners, when they're letting property or when they're selling it, when you represent a buyer or a tenant? What is it that your role is specifically, and what are the guardrails on that in contracts? So what are the protections that brokers have in their agreements with their own clients? Limitations on liability, right? How good are those protections? And then we ask, if you're a broker for a large brokerage firm, what protections do you have vis-a-vis your employer? Do you have an indemnity there? Even so, does it only cover your negligence? Right? This mirrors your insurance coverage. When you get sued for professional liability, and you send the claim off to your insurance company, do they say, "Oh, we cover negligence. You knew this. You made a decision. That's not covered." Just like it's against the law to insure against intentional torts. If I'm negligent and run you over with my car, insurance can pay. But if I decide I want to run you over because I don't like you, insurance, it's against the law for them to pay. So what is really the scope of the insurance protection? And oftentimes you'll see that they're saying they will only insure you provided the brokers do these things. You have these policies in place, right? You take some responsibility here, and that your contracts with your clients limit your liability consistent with whatever their requirements are.
Let's see.
All right. So this I put here because you have them, we have them. Banks have borrowers who are these people. Rick has them. The cowboy client, right? It's the developer, it's the business owner who's just, I'm good with risk, and they may or may not appreciate any of this, right? I would advise that when you're in a transaction as a broker on any side, that you advise your client in writing to disclose all material environmental facts. When you do that, remember, your cowboy client is going to say, yeah, thanks for sharing. You're not a business person. I am. And they won't say anything. But if you provide that in an email to the client's lawyer and the client at the same time, the lawyer has a very different ethical obligation on what to disclose. So I would do that. It would be good to remind the cowboy buyer or tenant that lenders don't share their appetite for entrepreneurial risk. You know, they may end up going all the way down this road for months and months of your time where you're letting other buyers or other tenants walk. And it turns out the lender's never going to finance it because the cowboy thinks, I know a guy at the bank. You know, you also may want to talk about whether contractual protections are going to be are adequate. Like, will the lender, even though you have liability, and even if the remedial cost could be 800,000 to 3 million, is your bank going to be happy because the lender says, I negotiated a contractual indemnity from a seller? As we've already talked about, when the seller takes the money at the closing, it will be distributed and they will cease to exist. How is the lender protected there? Flagging those things up front will avoid wasting lots and lots of everybody's time that's valuable. You can advise them of the brownfields program we talked about. In every commercial lease transaction, in every purchase transaction, your clients should be getting bona fide prospective purchaser certificates and bona fide prospective tenant certificates as a matter of course. As you find yourself kind of the, vox clamantis in deserto, the voice crying out in the wilderness, and your cowboy client isn't listening, you still want to emphasize to their lawyer, right, that they want to engage a consultant and with their lawyers, environmental lawyers, as quickly as possible. And that's so that you don't end up wasting times on terms and efforts and financial deals that are never going to happen and that can't be financed anyway. We don't have time, but I'll just summarize a recent case study in mismanaging a cowboy client that I had in the last 2 months. A really unique cowboy, but came in with his own consultant recommended from a lender. A lot of these small lenders, you're on their list if you took them to lunch or if you're cheap. And so, then your client ends up using them to do the work. They may not have the DEM staff or the director on speed dial like Rick does, and the process alone may be that even if they're right, they can't deliver it in time to close. They can't address an ASTM standard phase 1 or phase 2. So it is all consulting firms, just like the real estate lawyers and environmental lawyers you work with, they are not created equal, and the results show it. And so I would encourage you, where you are starting to get the feeling that you have the cowboy client, that you begin to push them towards legal and consulting as early as possible in the deal.
We're going to open it up for questions. And if you could, maybe if I'm going to go to the chat room here. Let's see. Okay. Not seeing much in the way of chats. We have a quiet audience here, Mike. If anybody would like to ask a question, pose a hypothetical scenario that might be confronting them at the moment, please share it with us. And don't be shy.
I know you have clients and you're marketing property and there's hair on it and you don't know what you should or shouldn't. How do you properly disclose to protect yourself but not lose your client because they think you're catastrophizing something that they minimize? How do you do that? Are you going to go look at your insurance policies and see whether anything you think is covered professionally is? Mm-hmm. Have you ever obtained a bona fide prospective tenant certificate for your clients that go in and rent commercial properties? You should.
Yep.
How long does that take, right? Quickly, a couple days, 2 weeks outside. What are the lending considerations and how can you help them?
Come on, people.
Don't make us call on you.
That's right, Julie. All right. I'm gonna say going once, going up. Alex.
Well, I was thinking about, why don't we just share with us what is the most, I wouldn't say the most common mistakes that you see in the commercial industry just because, oops, forget about it or didn't do their job. Or like we're talking about disclosures, that the seller, the cowboy guy, didn't say, no, I don't want to say this, I don't want to say that. What is the most common in the environmental you're seeing in the commercial side, like landfills or probably those kind of the brownfields as well on the
Are you
sewer?
asking what are the most common
Yes, what do you
items
see?
missed in transactions that we discover later as problems?
Correct, yes, just as a reference for us.
Yeah, so it really depends on the level of sophistication of the deals you're working on. But like for instance, everybody drives by every farm and they go, geez, I wonder why that farm isn't a subdivision. You know, why has it been sitting there forever? Well, the reason it is completely skunked with arsenic, because all of the pesticides for 100 years contained arsenic and heavy metals. And so the law is that as long as your contamination, which wildly exceeds residential standards, as long as it arrived on the property as a properly applied approved pesticide, and you're still using it as a farm, there's no remediation requirement. However, the moment you flip it out of farm use, now you're subject to the regulatory requirement. So you got, 75 acres where you got to deal with the top 2 feet of soil. And, that's a challenge. And so that's why you drive through South County and you see a lot of land that's undeveloped. That's kind of one thing that is often missed.
And I would also add that probably the most common environmental issue that we see that results in a release to a property is in whole or part associated with some form of underground storage tank, whether it be former or current. The insurance industry did a deep dive on the environmental due diligence process a number of years ago, where they determined that approximately 80% of the contamination issues that arise during the due diligence process are somehow related to underground storage tanks. And in addition to that, over 60% of the environmental issues that are surfaced during a phase 1 are the result of an on-site inspection by an environmental professional. So far and away, environmental issues are surfaced by experienced EPs when they're doing their on-site inspection, right? They're out there looking around on a property and oops, oh yeah, there's a vent and fill, or oh, there's a floor drain. So to Mike's earlier point, you get what you pay for. You want to recommend to your clients that they hire experienced, not just somebody that's been in the business for a long time, but experienced in the particular state that you're working in as a consultant.
Right. I'll just say that what you all often see with successful commercial brokers is they have a stable they go to. right? They'll have a couple of lawyers that they rely on to help their clients, or they'll have a couple of consulting firms. But you're going to develop relationships with these people over time, and you'll maybe decide, oh, I didn't like the way that went, or that advice wasn't correct, or they mismanaged the client relationship, or whatever. But eventually, you should settle on your own stable, each one of you, because your ability to close, I mean, you want to bring a property to market, you want to close it and move on to the next one. And who you bring in, and or who your client brings in, can wildly impact the ability to ever close, the ability to ever package it so that it's financeable, right? Or, the kind of the timing. Maybe it can close and it can get financed. It's just never, they can't deliver it on the time frame that you need to have the deal close. Two other things, Rick, just following up. So one other thing that you don't think about a lot is that because we're a colonial state, throughout the Northeast, everybody we have so many properties that have been filled over time. So almost all fill is contaminated above standards, and it has common, it shares common constituents, but filled land is an issue, even if there's no ongoing release, or there was no chemical release or a tank release. Just moving fill onto a property when it came from typical construction sites, or underneath a road, or from some other, kind of developed area, you're likely to have contamination that you'd have to address. Which also brings us to the question of, if there's any water body around this property, it's not necessarily part of a typical phase 1 or 2 that you would do. But I mean, Rick can tell you, whenever I work with him, I always want him to go back and grab the aerial photos, going back as far as we can. You'd be surprised how often we look at properties along the ocean, or say the Providence River, the harbor, other wetlands, where over time, the properties have been filled, these wetlands. And under state law, if it's after the adoption of the wetland statute in the 70s, you can be ordered to restore that by just being the current owner. If it's related to the ocean, or a quote unquote navigable water of the US, or a tributary thereof, then the Army Corps of Engineers can make you dig back that lovely waterfront yacht club 100 feet. So we want to just to be aware that wherever there's water, there's likely been filling, and your consultant can run that down.
Right. Any other questions, comments?
I have a hypothetical.
Julie, now for those of you who don't know Julie Freshman, she was a former consultant for many years, and I really enjoy working with Julie because we talk the same language, and she can be, whether she likes it or not, a great resource to you folks out there in the real estate community. Julie, hit me up.
Thank you. Thanks, Rick. I like working with you too.
Thanks.
And you're a great resource now that I'm a broker. So
Thanks.
same with you, Mike. So here's the hypothetical. Let's say you did a phase 1 that went to a phase 2 for a buyer, and then that deal didn't go through, one reason or another, not necessarily because of environmental, but it was terminated. Now there's another buyer, and everyone's aware that, because it's a small state, and that Sage did the phase 1 and 2 for the previous buyer. What would be the best way to, not having to recreate the whole wheel, right? You did it for another buyer, not the seller. So how do we get what's the best way to get that information maybe to a new buyer, or at least get them in touch with you, or, what's the best route to take?
Mike, can I take this one?
You can. I'll have something to add on the contract, but yes, go ahead.
Okay. So, in that scenario, I, as the consultant, would say to a new prospective buyer, listen, yeah, I may have been hired to do this for a previous buyer, but you're going to have to talk to that previous buyer about giving me permission to, one, get that report released to this new buyer. And typically what I will recommend is that this new prospective buyer offer to pay something towards the expenditure that that previous buyer made in that due diligence. Does it work all the time? No. But it's sometimes it will sometimes work that way. And I
Yeah.
need something in writing in the form of an email. Yes, Rick, you have permission to talk to this and release that data. And hopefully there's been an agreement between the new buyer and the old buyer to release that report.
Got
Yeah,
it.
Julie, it's I enjoy working with you, and you could be giving this talk as well. So there are a couple of things to think about in that regard. And I end up, as you know, Julie, this has happened before, is that if you have, like, let's just hypothetically talk about a large oil company that's selling all of its holdings in the state.
Mm.
I may represent somebody who goes in to look to buy it. And if that deal craters, the odds of the next buyer calling me are pretty good. There aren't that many people who do environmental law of that nature in Rhode Island. And so I have a decent shot of getting that call. And I may run into the same lawyer in-house on the seller side I had one where I did for 6 buyers. So all the stuff I negotiated in the contract for the first, I just keep moving the needle, right? And so it's but one of the things everyone has to be aware of is, imagine that Rick did the work, but he was retained by me. And what then happens, even though the client paid for it? So that's a complication. The other is where the access to the property for Rick to do work was only granted with very strict confidentiality provisions under contract, like we talked about earlier. In that instance, if the potential buyer who signed the confidentiality agreement walked away and then released Rick to provide everything he learned to some third party, does it put that Rick's former client in a breach of a contractual provision that survives termination of the agreement?
Mm-hmm.
So those are just things that would have to be fleshed out.
Yeah. All right.
All right.
Useful.
Thank you. Any other questions, folks? Or any experiences you might want to share?
I have couple a year ago. There was a gas station close by to my house, and it was for sale. Good deal, $900,000. It was with a dealer and all the stuff all together, and repair shop. So my client loved it, want to make an offer. We were dealing with the not with the price, but with the DEM. And of course, the bank is going to be financial, is looking for phase 1 and 2, maybe 3, just in case. The owner passed away. Unfortunately, there is no information about the property. And this is sharing the experience that I have on this transaction. Long story short, the oil tank, it was from 1970, and unfortunately it was leaking, and nobody wanna disclose that information, and my client decided not to buy the property. Year later passed, and they sold it, and a cash buyer half of the price on that. So I believe it's basically no DEM involved, but you get it into the situation. You buying a property with a huge liability with contaminations on the field.
Right, so that was my cowboy example.
Yeah.
We have those.
Yeah.
I mean, there are people who we cannot save.
Yes.
They're
Keep
going
that
to
right.
buy anyway, and
Yeah.
they think somehow that they can take the risk, and they'll be, they're business people, so they'll take the risk, and
Yep.
they don't need financing. And you're like, yes, but you will, when you want to sell the property, that person may need financing.
Mhm.
Or if it's a gas station and you want to do what a lot of them do, which is bring in, somebody who you're going to lease it to and let them operate it, right? They may not want to walk into that. So it's eventually this bill will be paid, and you might want to understand what the bill is and negotiate it as you buy the property, rather than just assume that because the bank isn't involved, that these risks don't exist. They do.
They do. Yep. Thanks for the question. We've got about 10 minutes left. Going once. Going twice. All right. Well, folks, thank you for your time and patience today. Really appreciate it. And you've got our both Mike's and my contact info here at the end. You can also get a hold of us. I know when Jack posts this presentation on the RIBCOR website, you can get a hold of us that way as well. So again, appreciate all your time, and thank you.
Thank you, Rick. Thank you,
Thanks,
Mike.
everyone.
All right,
Jack,
guys.
Enjoy the rainy evening. Stay dry.
All right.
All
Thanks
right.
all.